one is Mr. Jarman for Erin O'Toole.
Sir.
Morning, Mr. Tom Jarman on behalf of Erin O'Toole.
Morning, sir.
I'm going to ask you a couple questions maybe that fill in some blanks around what my colleagues have asked. And the first one is, so prior to COVID's onset, you were getting information, briefings, et cetera, in the regular flow of business at your office in Ottawa. Is that correct?
For a relatively brief period of time, but prior to COVID, there was more information coming through the Department of Public Safety from CSIS.
All right. And you're aware that there's positive control over top secret documents?
Yes.
And we can determine exactly where those documents land at any one time.
Well, I'm aware of, frankly, I'm very aware of the system that we have in place at the Department of National Defense for the tracking of those top secret documents. I think that the testimony that has already been entered before this inquiry shows some deficiency in the tracking of top secret documents, not compromising their security, but who they actually got to.
Possibly within your office. Was such a tracking system in place within your office?
I believe that information that was received was tracked, but we didn't, of course, we weren't able to track the information that was not shared with us.
Right, thank you. You have political staff working for you in your office, and we refer to them as exempt staff. Is that correct?
That's correct.
And they exist to represent you with respect to the various departments that you're dealing with?
There are a number of different functions within every ministerial office, issues around policy, parliamentary affairs, working with other members of parliament. There are issues, people that deal with my scheduling, et cetera, and part of the minister's staff.
All right, thank you. And we heard from Ms. Astravas that there were 2 people in your office in public safety who were assigned the responsibility to review warrant applications. Is that your understanding?
And again, Ms. Astravas ran the minister's office and had personnel who had certain duties and assignments with respect to it. I know that work was done and is necessary to be done, working with public safety and CSIS to bring the document when ready for my attention and action.
Were those staff providing you with advice with respect to the warrants?
And again, the advice that I received from the warrant is based on it statutorily. It really comes from, I did not receive advice either from the chief of staff with respect to the signing of a warrant or any of the exempt staff that you referred. It is my legal responsibility with respect to those warrants was determined by a letter of recommendation signed by the deputy minister and then a briefing provided by CSIS officials.
So if your staff were not providing advice, what was the purpose of having them review warrants?
And again, they would work, I think, with them to make sure that the document was any questions that needed to be resolved prior to it being brought to my attention, that work would be done. My expectation that all the parties responsible would exercise due diligence in bringing the warrant forward to make sure that it was appropriate in both form and substance for my consideration and approval.
And you'll agree these warrants are fairly complicated documents, often verging on 80 to 100 pages with respect to the affiant's claim or case that the warrant should be executed.
I certainly would agree that they can be quite complicated, and there are a number, in addition to the affiant's statement that is submitted in support of the application. There are a number of other related documents that are part of that. Although I'm quite familiar with the form and substance of such applications, it can be complicated.
Yes, and neither Ms. Astravas nor the other staff member assigned to review the warrants was a lawyer, were they?
I don't believe at that time there were any people with law degrees on the staff.
Are you aware whether or not they had prior experience with respect to national security documents prior to working for you?
I don't believe they did, but they were, of course, vetted, and there was some training that was provided by PCO and by the national security agencies with respect to the security of the information that was being shared.
Was that the only qualification they would have with respect to the review of warrants?
They did not have legal training, as you pointed out. There was some training about and requirement that they become familiar with the process and through discussions as has been previously entered as evidence that there were a number of these applications coming forward.
All right, thank you.
So they'd be familiar with those processes.
Were you ever briefed with respect to concerns regarding Han Dong and the Don Valley North race?
And again, I have been subject, or had a number of briefings with CSIS. I'm going to turn to you with respect to this matter, but
There are documents before the commission where staff of the Liberal Party and the Prime Minister's office are briefed in September and October of 2019. Do you recollect any contemporaneous briefings with respect to Mr. Dong or Don Valley North shortly after your appointment as Minister of Public Safety?
shortly after my appointment of Minister of Safety, I had conversations with the Director of CSIS as part of the several months before briefing to which we've already referred in this hearing, in which information with respect to potential political interference involving a number of people was discussed. And at that time, I became aware of the information you've referenced.
Okay, thank you. Could we bring up EOT 17 and go to the bottom of page 17 PDF, please? So this is the 2022 NSERA annual report. NSERA reviews the activities of CSIS. Go to the bottom of the page, please. And you'll see there, sir, that it records that in 2020, 15 Section 21 applications were approved, and in 2021, 31 were approved. For the prerequisite for approval is, of course, that you approve the warrant being presented to the federal court. Do those numbers seem consistent with your experience?
Yes, sir. I have no basis to dispute that. As I've earlier testified, I don't know the precise number, and if this is the number that NSERA has provided, then I accept it.
Okay, and so particularly in 2020, when you were the minister for the entirety of that year, that means you would have attended at a SCIF at least 15 times to receive a briefing with respect to these documents.
I can tell you that in every single case where I signed off on these documents, they were presented to me in a secure facility, a SCIF, every single time.
And there would have been ample opportunity to present other top secret documents to you as well during those occasions.
There's no reason why not. If other top secret documents, if CSIS wanted to share them with me, that I would be in a location where that could take place.
Okay. And in your evidence, you testified that the standard or the usual process was 4 to 8 days for the presentation of a warrant to you. Do you agree with that?
Well, again, I think there are some circumstances, as we've already testified, there are some circumstances where CSIS would indicate that there was a matter of urgency with respect to the signing. And that could be an operational urgency, and it could be an administrative one if, for example, an existing authorization was expiring and they needed to renew it.
All right. I'm going to draw upon your previous experience as a law enforcement officer. You've had extensive experience dealing with warrants, both as a supervisor and as an affiant. Is that correct?
Yes, sir.
And as a result, you're aware of the importance of timeliness of the presentation of the affiant's evidence to the court.
It can be quite important.
Well, isn't it always important?
And it needs to be accounted to the justice when you're bringing the affidavit and the application forward.
Because the longer the time passed, the greater the likelihood that the justice will say, I need contemporaneous evidence in order to evaluate this application.
And again, a lot would depend on the circumstances, and so it's hard to comment on a hypothetical, but at the same time, I do understand the principle of timely bringing forward the information before a justice for their consideration.
And when these applications were presented to you for approval, they always included the affiant's affidavit and whatever supporting evidence and exhibits were attached.
That's correct.
To those. And you reviewed those in detail, didn't you?
Yes, sir, I did.
And wouldn't you have noticed the date of the affidavit when the affiant swore the evidence?
And again, that information was not available to me. I did not see anything in those applications that caused me any concern. And again, in my conversations with the director, he did not indicate any concern with the timeliness of the application.
Sorry, sir, that's not my question. My question is, when you reviewed the documents, you're reviewing the affidavit. The date of the affidavit is actually an important part of the application.
And again, I have no recollection of what the date on any of those applications were, but I did read through the application to determine its substance. And as I've previously testified, not at any time did the director of CSIS or any CSIS officials express to me any concern with the timeliness of my approval.
Sir, but I'm putting it to you as your concern as an experienced law enforcement officer, aware of the importance of timeliness of these things. You would have paid attention to the date of the affidavit.
No, if I may, sir, I read the document in total. I did not see anything that caused me concern with respect to the timeliness of the application, and CSIS did not raise to me any concerns either at the time or subsequently.
Forgive me, sir, I'm not
with
speaking about
delay.
any particular warrant. I'm talking about as a general matter of practice. You would have looked at the date of the affidavit, wouldn't you?
Again, sir, and I looked at the affidavit in its totality, and there was nothing in the affidavit in that or in any other warrant application that caused me any concerns with respect to the timeliness of the application.
I'll conclude with this last question then. When your staff were reviewing the documents, the affidavit documents, if it came to their attention they had a personal relationship with either the target or someone identified on the Van Wienen list, was it appropriate for them to continue giving you advice?
My expectation is if any of my staff, and this has been well communicated, we have standards of conduct, and my expectation is everyone would understand the rules with respect to declaring a conflict of interest. That did not take place in any of these matters.
Thank you, sir. Thank you, Commissioner.
Thank you.